The next appeal is appeal number 12. Welcome back, counsel.
Good afternoon again.
Chief Judge, this is Stephen Seeger. Can the court hear me?
Yes, I can. We can all hear you, sir.
It doesn't appear, Your Honor, that the video portion of my computer is working.
Is working or is not working?
It is not.
Okay. Well, as long as you're comfortable, the court is comfortable with you proceeding through use of audio only, and you may begin, sir.
Well, Your Honor, I've been told I have a face made for radio, so perhaps it's more appropriate anyways, but may it please the court. My name is Stephen Seeger. I represent the appellant here, and I would like to first point out that the facts here are unique to a posthumous.
Mr. Seeger, excuse me for interrupting. I'd like to ask you if you would like to reserve some rebuttal time, sir.
No, ma'am.
Okay. Please proceed.
The facts here are unique to a posthumous schedule loss of use award, assuming that's how it's best characterized. And it's unique in the sense that claimant permanency funds for impairment, permanent impairment to both arms were found some 6 months prior to the time of his death by both the employer's medical consultant and by his treating physicians. Therefore, an argument, and I believe a strong argument, could be made that these schedule awards were not posthumous, but became due, in fact, before the time of death. However, using Healy versus Carroll and the appellate division's decision below, it's clear that these posthumous schedules became due or were due at the time of death. I think the only issue, obviously, here is the dichotomy or the paradigm used by the appellate division to, in citing Healy, that there is an accrued portion of a schedule loss of use versus an unaccrued portion.
Well, sir, this is Judge Stein. I don't know. Can you see us?
I can. Yes.
Okay. All right. Good to know. What is difficult for me to understand is that regardless of how we say or when we say these benefits accrued, two issues that I'd like you to address. One is that wouldn't your interpretation render Workers' Compensation Law 15.4D completely eviscerated? And if so, where do you see support for a legislative intent to do that? And the other thing is that Healy was existing at the time for many, many, many years at the time of the 2009 amendments, and the legislature made no reference to changing the rule or impact of 15.4D. So isn't that something that really needs to be addressed to the legislature?
I don't think so, Your Honor. I don't believe that my argument here is a call for the evisceration of 14D. It's simply a broadening of application of Section 33 and a narrowing or a restriction of the application of 14D. 15.4D would still apply to non-scheduled permanent partial disability payments under the same circumstances.
That may be, but the statute itself doesn't limit it to non-schedule awards. It includes schedule awards. And it just seems to me that it it is consistent with the legislative intent in both in enacting the lump sum payments and before that, to say that, look, when there's no dependence, that once the injured worker has died, you're limited to these funeral expenses, other than what payments were due to you before you died.
Understood, Judge Stein. But not only does 15.4D still apply to the non-scheduled scenario, but it does apply and does find some application, however narrow, to a schedule loss abuse that is paid to a claimant or awarded to a claimant during his or her lifetime, where that claimant opts to be paid in periodic payments. We're just simply asking that this situation, that is where there is a posthumous schedule loss abuse award, that again, according to Healy, according to the appellate division below, becomes due at or before the time of death. Now, if it becomes due, that invokes Section 33 of the Workers' Comp Law, which takes 15.4D out of the equation and out of the application and brings Section 33 in, so that the schedule loss abuse may be made payable to the estate. Once that occurs, it's our contention that the amendments, the 2009 amendments to 15.3U and 25.1B, allow the estate the additional right and authority to claim that award that's due in one lump sum.
Counsel, if I can just ask, if we adopt your interpretation of these various provisions, would that encourage an injured employee who has received an SLU award to request a lump sum payment in the hope that they're going to get that payment, all of it, before they die?
Well, I think that's the practicality of it, Your Honor. I mean, I think there's certain financial incentives to request that a schedule loss abuse award be paid in lump sum because of present value considerations, but also because of the issue of legacy, of course. I mean, I think that goes without saying. Yes.
So what, in your view, I'm sorry.
Counsel, the stated purpose behind the 2009 amendments, let me read this, is to allow the injured workers to invest their awards up front and better prepare for the financial and emotional effects of their diminished earning capacity. So how would the payment of the entire award to the estate further the purposes that were explained to undergird the amendments?
Well, I think, Your Honor, I think that's a situation that must incorporate the definition of what a schedule loss abuse award really is. If it's clearly distinguishable from a non-scheduled permanent partial disability in that there are no continuing payments per se unless the claimant opts for it. And as this court has said in McCroy and also in Mancini and many of the appellate division cases below, the schedule loss abuse is not allocable to a particular period of time. It's not dependent upon any lost time from his or her job, and the purpose is to compensate for loss of earning power. I know the respondent here asserts that a schedule loss is for pure loss of earning capacity, and I don't believe that's what the recent case law post-amendment actually defines a schedule loss abuse award. So to the extent that a schedule loss abuse award is a unified whole, I think our position here that it accrues or becomes due is maybe the more appropriate phrase at the time of death, if not beforehand, is key. And I might also add, Judge, that because the basis of the foundation here in this case for the claimant schedule loss of use awards were made in undisputed fashion 6 months before he died, it does seem somewhat unfair given the remedial legislation that the workers' compensation law embodies to deny him or his estate in this matter of that award that he should have otherwise had, but for some unfortuitous, except for his unfortuitous death that occurred again some 6 months, after these findings were made.
Counsel, this strikes me, although I don't know anything about the practicalities of workman's comp law or practice, as a very unusual situation. Is that right? That you'd have a scheduled loss of use where the award is posthumous and the cause of death is not related to the injury? Does this happen much?
No, not in my 34 years of practice, Your Honor. It's a very unique setting.
The reason I ask that is the following. I wonder what your view is on whether Healy is consistent with 15.4D. And the reason I put those two together is this the sort of issue that ever would have come to the legislature's notice?
I think precisely my point, Your Honor, although I probably didn't do a particularly good job of articulating that, is that because there is this companion or alter ego of 15.4D in the form of Section 33, I don't think there's a need necessarily for the legislature to step in and amend 15.4D or other provision of the workers' comp law in order to accommodate what we're asking the court to do here. If the award is due at or before the time of death, 33 serves its function. And again, the amendments should offer no impediment to that payment of the scheduled loss of use award being paid upon request in one lump sum.
Can I ask, Judge, one of the things I've wondered when I went back and read Healy, which is in essence created a compromise in a way to read both of these statutes together. What's your position on this? Can these statutes be read together? Does the legislature have this right to do this? Or does the court have the right to create this compromise with Healy, or is that purely a legislative matter? Have you given any thought to that?
Well, I think Healy was more easily decided, Judge Fahey, prior to the 2009 amendments. I think it was
well, the question that comes, let me stop you. The question that comes to mind, if the 2009 amendments eliminated 15.4D, then why didn't they say that?
Well, but again, to my point, I think it was to Judge Stein. 15.4D did not eliminate entirely. It did not.
But it did eliminate to a particular class of people. So I think just that Judge Fahey's question is still pertinent. If they intended to eliminate it for a significant class of people that fell under that that provision, then why shouldn't they do that?
Well, again, my position is because there's a legislative enactment that already takes care of, that already applies, that finds application.
Well, the question is it's a general versus specific. 33 is a general. Is this a carve out under Section 33?
No, in all due respect, Judge Fahey, that's the respondent's point of view, that it is general versus specific. The appellant doesn't contend that here.
All right, let me ask you just a slightly different area. The word accrual itself, does 33 set the accrual on the date of liability or the date of award? In other words, the
Well,
date the accident happened or the date the award came down? What's the accrual date?
Well, I don't think it's either, frankly. I
Okay,
think
when is
that
it?
Section
What-
33 under Healy and under the appellate division below, the accrual would be, well, there are two, there's accrual and when the award is due. The accrual date would be the date of accident running from that point up until the date of death.
All right,
But
let me stop you.
33,
For most, I know of no other area of the law where the accrual date doesn't mean that's the date that damages begin to count from. That's the date you measure from. Now, you may get your award 6 years later or whatever, but when we count them, we're counting them from the date of accrual, the date that damages occur. And so that's how, the purpose of that, of course, is to measure liability. It's not measuring liability, it's measuring the amount of damages once you determine liability. I know of no other area of the law that moves that date except for here. And that's why I asked if they were in conflict. Does that make sense to you? You understand my question?
I believe I do, and I'll do my best to try to respond to it. I believe case law is replete that liability for a scheduled loss of use arises on the date of accident.
No, I'm asking you a larger question. I'm asking you not just in workman's comp. Is there any other area of law where the damages don't begin to run from the date that the damages occurred, the date of accrual? In an automobile accident, in a wrongful death case, in any other area, in a contract action, the date that the breach occurred, right? Whatever it is.
Well, I think it is somewhat unique in that regard, Judge Fahey.
Yeah,
I do.
I do too. Here's the problem I have, and this is what I struggle with. I do think that this does seem unfair, or but I have a hard time reconciling, and I don't really like it. But I'm wondering, why doesn't the legislature have the right to do this, since the whole workman's comp system, it seems, was established in lieu of the common law to balance the interests of employers and employees. So I guess it seems we would have to say that the legislature did not have this right to carve out this area in order for you to be successful.
Judge, and again, I'm not sure if I necessarily disagree with that, but what I would like to say is, and perhaps I'm redundant, and I apologize if I am, but Section 33 uses the word when an individual dies, that any compensation may be taken by the spouse or statutory survivors, or if there be none, then by the estate, of compensation that was due at the time of death. Now, Healy and the appellate division below say that the scheduled loss of use award, posthumously awarded, was due at the time of death. If we accept that, if the court accepts that, then my position is the legislature need not amend 15.4D to allow the amendments of 15.3U and 25.1B to apply, because the right of the estate to take that award is due and otherwise payable per 33 at the time of death.
I see. Thank
And
you.
I think that distinguishes us.
Thank you.
Are there any other questions of the court?
No, sir. Thank you very much. Mr. Duchenne? Unmute yourself, sir.
Sorry about that. Good afternoon, Your Honors. Corey DeCrescenz on behalf of the respondent. I may please the court. We're here today on agreed, a very unusual set of facts. The claimant was found to be a maximum medical improvement per both doctors, and before the scheduled loss of use was implemented at the board level, unfortunately passed away. It is, I agree with Mr. Seeger that this does not happen very often before the board, and it triggers a very specific set of statutory enactments. Our position is that the 2009 changes to allow living claimants to collect lump sum schedule loss of use awards has not impacted the Healy analysis on 15.4D and section 33.
So counsel, if I can ask you, does his interpretation or yours encourage, as I asked before, an injured employee who has an SLU award to demand the lump sum payment so that they don't lose all the money?
Yeah, I think practically before the court, there's very few instances where a claimant tends to, elect to receive a scheduled loss of use award by periodic payments instead of a lump sum. So I can't see arguments in this case having a very broad impact on implementation of scheduled loss use awards in general at the workers' comp level.
I'm sorry, because you're saying usually people want the lump sum? Is that what you're saying?
Yes, Your Honor. And again, I guess our point is just that essentially LaCroix did not impact 15.4D. Again, as several judges have pointed out, if the legislature had meant to do so, it certainly could have. It could have removed that section or amended it in any way, but it did not.
How do you respond to the argument that it's arbitrary, that if a worker had selected the lump sum payment the day before the worker died, then the estate would get everything, and if the worker selected only periodic payments, then they're limited in what they can get? How do you respond to that argument?
I guess you need to know a little bit more about the timing. It may seem arbitrary on its face. I guess the counter argument is that one of the purposes of scheduled loss of use awards, as we previously mentioned, was to compensate a worker for a future loss of wage earning capacity or diminution of earnings. Here, the claimant has unfortunately passed. There is not going to be a future loss of earnings. So to the extent that this may be why 15.4D was put in to essentially as ameliorate the negative effect of the claimant's estate getting nothing, they are
But
getting
counsel, if I can interrupt you, I think Judge Stein's question is a little bit different from that. I don't think anyone's disputing the statute as you've described it. I think her point is that anomaly, I might change the hypothetical slightly, of someone who gets the check because they asked for the lump sum, cashes it, next day they die. So they've gotten all of it. And if they didn't spend it, it's going to the estate, versus the person who wants the lump sum, requested it, but the check has not yet arrived. And so they just didn't have an opportunity to cash it. Where's the fairness there? Let me put it a different way. What's the legislative purpose that is served by the law working in that way?
In other words, what's the rationale for the death gamble?
to be honest,
Well, it's not even a gamble. In my example, they both want the lump sum. The problem is they're waiting for the check, which they have no control over. The award determination may take some period of time. I mean, cutting the check, however it's paid, you get my point. As I say, what is the legislative purpose that's served by that being the result? Because I understand that's the result of your interpretation. I could be wrong.
Yeah, if you would clarify that, because my understanding was if the election by the worker had been made, but the check hadn't been received, that would not be a different result. But maybe I've misunderstood your position.
I think I might be confused based on the timing. Essentially, the election's made usually in practice of the workers' comp board at the time that the stipulation is entered before the board. So, I mean, typically the claimant's alive, they elect to take a lump sum award, and it's resolved. If claimant passed the next day, the decision's already entered at the workers' compensation board level. At that point, I would agree the award would be due to the estate if the decision's already been entered. This is just unfortunately a factually dissimilar circumstance, which is limited to 15.4D. I don't disagree that it may seem on its face arbitrary when argued as Mr. Seeger is taking the position, but that is the statutory
So I'm sorry, I've misunderstood this record. I'm confused. You're saying that the decedent here did not request the lump sum before passing?
I believe that I believe he passed before the decision was entered. And so I don't believe that actual implementation of the decision requesting a lump sum had actually been made.
Okay, so that was my misunderstanding. Okay, so then my hypothetical, there is no such situation as my hypothetical, because the person would have to have had the award and then say, I want that as a lump sum, as opposed to when there's still an open decision about the amount of the award?
I guess practically the way it works is in a general case, claimant's doctor says, one schedule loss use, IME says another, and then the parties either, come to an agreement that this is the schedule loss of use, or the judge makes a decision and then it's reduced to writing, decision dated 1/1/21. And typically before that decision's entered, claimant will request that either at the hearing or in memorandum of law that this award be paid in, in a lump sum per 15(3)(u). And so that's usually when it's entered. So one of the disagreements I have with Mr. Seeger is he continually maintains that, this award is accrued before the passing and is payable before then. My position is that it's not. He passed before the decision entering the schedule loss of use was made. If this had been a Section 32 settlement before the Workers' Compensation Board, I believe the carrier would have been free to essentially withdraw from that. It was not yet.
So then, I'm sorry, I'm just still trying to get past this issue about the record. So are you saying that the estate administrator is the one who said, we want a lump sum? The decedent, while he was alive, never said, I want a lump sum payment.
I do not believe that was stated in open court before, but without going through every single document,
So Chief, if I might ask a question. Counsel, what is your understanding of the first moment that there was due at any time any compensation on this record?
Sure. Lost time. Compensation, often a term of art just for lost wages at the Workers' Comp Board. So claimant sustained an injury and was out of work. So at the moment he began losing time, that would be the when compensation became due.
Anything further, counsel?
No, I'm fine resting on our brief, and we again maintain that the proper remedy here would be legislative rather than judicial. Thank you.
Thank you. Thank you to both counsel. That concludes this afternoon's calendar.